Does your use substitute for the original? Does it harm the owner's ability to make money from it?
Those four factors. And we saw them play out recently in that big Supreme Court case, right? Andy Warhol Foundation v. Goldsmith.
Exactly. A really important case. The court looked at Warhol's prints based on Goldsmith's photo of the musician Prince, and they decided it was not fair use. Even though Warhol's style was different, the court focused heavily on the fact that Warhol's print served a similar commercial purpose, licensing to magazines, as Goldsmith's original photo. The first factor, purpose and character, weighed heavily against fair use in that context.
So just changing the look wasn't enough if the commercial purpose was too similar.
That was a key part of the ruling, yeah. It really highlighted the importance of that market effect factor, too.
Interesting. How does that compare with Korea? You mentioned they have a fair use concept, too.
Korea's Copyright Act, Article 35-3, allows use for things like news reports, criticism, education, research, and so on.
Similar purposes.
Right. But the condition is it mustn't unreasonably prejudice the author's legitimate interests or conflict with the normal exploitation of the work.
Okay.
And Korean law also considers similar factors to the U.S. purpose, nature of the work, amount used, and market effect. So there's overlap in the thinking, but the exact application can differ.
A similar balancing act, maybe weighted slightly differently. And there's that Korean case involving user-generated content.
Ah, yes. The father who posted a video of his daughter singing a pop song online.
That's the one.
It got taken down for copyright infringement. He sued, arguing fair use and claiming distress. It really highlights the tension, between copyright enforcement and freedom of expression, especially with all the content people share online now.
Yeah, that's something millions of people encounter. Okay, sticking with the digital world, obviously it's created huge challenges. Digital piracy seems like the elephant in the room.
Oh, absolutely. It's a global headache. Think about the film industry, especially in places like India, where bootlegging on social media and streaming sites causes massive losses.
And things like the DMCA in the U.S. help, but they don't completely stop it, right? Especially across borders.
Exactly. The DMCA provides tools like takedown notices, but enforcing them internationally is tough, and pirates are often quick to adapt.
What other digital age copyright problems are tricky internationally?
Well, orphan works are a big one.
Orphan works.
Yeah, copyrighted works where you just can't find the owner to ask for permission. It can stifle creativity or historical preservation.
How do different places handle that?
It varies. The Korean system is interesting. The government actually makes an effort to find the owner before potentially issuing a statutory license.
Huh. That's proactive.
Then you've got the rise of cloud services. That brings up issues around potential unauthorized copying when stuff is stored or shared in the cloud, and who's responsible, the user or the service provider.
Right. More layers of complexity. Is technology offering any solutions to these tech-created problems?
There are definitely efforts. AI is getting better at automatically identifying copyrighted content online, which platforms can use.
Content ID systems and the like?
Exactly. And some people are exploring blockchain technology as a way to create clearer, more secure records of ownership for digital works.
Interesting possibilities. Okay, let's break it down to practicalities. For someone just wanting to use content online, say an image for their blog or presentation, what are the key things to remember to avoid trouble?
Rule number 1. Don't assume anything you find online is free to use. Just because Google Images shows it doesn't mean it's up for grabs.
Right. Easy to find doesn't mean free to use.
Precisely. Most online content has some kind of restriction. Even if it's not immediately obvious, you have a responsibility to check.
Okay, so what about common sources? Licensed stock photos.
They can be great, but you absolutely have to read the license agreement. Seriously, read the fine print. It tells you exactly how you can and can't use the image, commercial versus non-commercial, attribution required, etc.
Don't just click agree.
Please don't.
What about Creative Commons images? Those seem designed to be shared.
They are, but Creative Commons isn't just one license. There are several different types. Some allow commercial use, some don't. Some let you modify the image, others don't. Almost all require you to give credit attribution to the creator. You must check the specific CC license attached to the image.
So still need to check the details. What about just grabbing an image from a web search?
That's probably the riskiest thing you can do. Unless it's explicitly marked as public domain or has a clear license like Creative Commons allowing your use, assume it's protected by copyright and you can't just take it.
Okay, so safest bet.
Create your own images, then you own the copyright, no question.
Makes sense.
And something often overlooked. Fonts.
Fonts have copyright issues.
Oh yes. Fonts are protected intellectual property, too. You can't just download any cool font you find and use it, especially for business. You need to check the font's license.
Wow, so what's the deal with font licenses?
Similar to images, some are freeware, maybe okay for personal use, but commercial use might require buying a license. You need to check things like, can you use it on a website? Can you embed it in a document?
So, same advice. Check the source, read the license, use reputable font sites.
Keep records of your licenses, and if you're unsure, especially for business use, maybe get legal advice. Better safe than sorry.
Definitely. One more clarification. People sometimes use copyright-free and royalty-free interchangeably. Are they the same?
No, absolutely not. And this causes a lot of confusion. Copyright-free, technically, should mean the work is in the public domain, zero copyright restrictions. But the term gets misused a lot online.
Okay.
Royalty-free usually means you pay a one-time fee for a license to use the content multiple times without paying additional royalties for each use. But there are almost always still restrictions in the license agreement about how you can use it.
So, royalty-free doesn't mean restriction-free.
Not at all. The best bet isn't searching for copyright-free or royalty-free. It's searching for content licensed for your specific intended use, or content clearly identified as public domain.
That's a really important distinction. Okay, so what happens when things go wrong? Someone does infringe internationally. How do you resolve that without a global copyright court?
Yeah, as we said, no single court makes it tricky. And these cross-border disputes are increasing because everything's so globalized and digital now.
So what are the options?
Generally, you've got three main paths: litigation, suing, and national courts.
Which sounds like a nightmare across multiple countries.
It can be incredibly complex, expensive, dealing with different languages, legal systems, and then trying to get a court judgment from one country enforced in another. Very difficult.
Okay, what else?
Arbitration and mediation. And international arbitration in particular is becoming much more common and often preferred for these kinds of IP disputes.
Why arbitration over lawsuits?
Several big advantages. A key one is expertise. You can choose arbitrators who actually specialize in intellectual property law.
Ah, unlike maybe a general judge.
Exactly.
Okay.
Institutions like WIPO, the World Intellectual Property Organization, or others like SIAC, AAA, HKIAC, have panels of IP experts.
Okay.
Arbitration is also usually faster, more flexible, and importantly, it's private and confidential, unlike public court cases.
Privacy can be a big plus.
And crucially, enforcing an arbitration award internationally is generally much easier than enforcing a court judgment, thanks to treaties like the New York Convention, which most countries have signed.
So practical tip for businesses dealing internationally.
Absolutely. Make sure your contracts clearly define the IP rights involved and include a solid arbitration clause, specify the rules, the location, everything. WIPO's Arbitration and Mediation Center is a good resource for that.
Got it. Can you give us a couple of quick examples of real international copyright fights? Just to make it concrete.
Sure. There was that dispute over the movie Old Boy, a Japanese publisher versus a Korean film company about remake rights and contract issues. Another involved the horror movie The Ring. A Korean writer sued DreamWorks in the U.S., claiming plagiarism of his screenplay.
Okay.
There was also a case where a Korean TV drama was broadcast without permission in Japan, leading to a lawsuit by a Chinese company against the Japanese broadcaster.
Wow, multiple countries involved there.
Yeah. And a really complex one involved a dispute in Japan over the copyright of a North Korean film. That brings in international relations on top of copyright law.
Right, those examples really show the tangled web it can be. Okay, we've covered a lot of ground. Let's try to boil it down. What are the absolute key takeaways from this deep dive?
I'd say, first, remember, international copyright is fragmented. No single law, no single court. It's a patchwork.
Patchwork, right.
Second, treaties like the Berne Convention are vital. They set minimum standards and provide that automatic protection across member countries.
Yeah.
But national laws still rule the details.
Okay.
Third, exceptions like fair use exist, but they vary a lot country by country. Don't assume U.S. fair use applies elsewhere. You need to navigate carefully.
Very carefully.
Fourth, the digital age creates huge challenges: piracy, orphan works, cloud issues. Technology offers some solutions, like AI identification, but it's an ongoing battle. And fifth, for resolving international disputes, arbitration is increasingly important. It offers expertise, efficiency, privacy, and easier enforcement compared to cross-border litigation.
So understanding all this, it's not just academic, is it? If you create things, if you use things online globally, you really need to grasp these complexities.
Absolutely. It's about protecting your own work and staying out of legal trouble yourself.
Which brings us to a final thought to leave you with.
Yeah, given how fast technology is changing and how hard it seems to be to update these international agreements like Berne, how can creators and businesses best navigate this shifting landscape in the future?
How do you find that balance, right,
Yeah.
between protecting creators' rights, which is crucial, and also encouraging innovation and the flow of information globally?
It's the big question. There are no easy answers, but hopefully understanding the pieces of the puzzle, like we've discussed today, Byrne, fair use, arbitration gives you a better foundation.
Definitely. And if any specific part really caught your interest, dive deeper. There's always more to learn.
Absolutely. Thanks for joining us for this deep dive.